Welcome to this Evershed Sutherland PROPcast. My name is Joe Geen. I'm a professional support lawyer to the real estate practice here at Evershed Sutherland. I'm going to be joined in a moment by Nadine Gutteridge, who's a legal director in our real estate practice. Nadine primarily supports clients in the energy and infrastructure sector. Our subject today is lateral infrastructure. Now, this is the sort of thing that comes up on most of the deals that we're involved in the real estate practice group. And of course, that's because people usually need to be connected to power, to utilities, to telecoms, to data infrastructure whenever they're doing a property deal and whenever they're setting something up. Nadine, welcome to the PROPcast and thanks for joining.
Hi, Joe. Thanks. Yes, I've been dealing with these types of projects for over a decade now. So I definitely feel like I've seen my fair share of good examples and perhaps some which haven't exactly followed best practice as well.
Excellent stuff. So, lateral infrastructure. It's a bit of an umbrella term. It's coming up more and more. Could you start by telling us what you understand the term to mean and what it means to you?
I suppose in simple terms, and in the context of the work I do, this is the real estate work to connect assets that generate power to the grid to allow for the distribution of renewable energy. In some cases, this may involve connecting assets with the same land ownership, whereas in others, the cable route for such a project may span hundreds of land interests.
I see. And of course, what we should say here is the reason that you're here on the podcast, you're talking to us about lateral infrastructure is because you are the expert in this sort of thing. So could you tell us what sorts of property deals you tend to get involved in?
It's really anything renewable energy, where land rights are needed, that is. This could be dealing with onshore land rights for offshore wind farms or interconnectors, to a solar farm, battery storage, or smaller onshore wind farms with just a few turbines. It's knitting together the patchwork quilt of various land interests to deliver the necessary land rights for a project to run. In some cases, this can involve securing rights from hundreds of landowners across different counties, all with differing interests. These may be freehold, leasehold, or even occupational interests, dealing with both registered and unregistered land.
So, as we mentioned in the blurb for this podcast, whether you're dealing with a massive offshore wind farm or perhaps a new unit on an industrial estate, really being able to connect for power, data, telecoms, utilities, that's everything. That's what makes that property viable. Now, fortunately, due to the scale of the deals that you've been involved with, Nadine, it's likely that you've seen it all. So when you're dealing with those swathes of land and hundreds of landowners, that gives the opportunity to really see what could be all the different angles that people could take on these things and how to address any challenges with solutions. So drawing on all of that experience and starting at a bit of a high level, is there an overarching ethos or a stance that you tend to take to these sort of transactions right from the start, in a way that sort of sets the tone and it helps them proceed effectively?
I think I would say it's really imperative to strike a good working relationship with the landowner and the developer team, as actually getting the land rights and securing those for the project, are key, in addition, of course, to the challenges of a planning permission or grid connection. It's always useful at the beginning of a project, from my perspective, to start off with a kick-off meeting. This should ideally include those with the technical expertise, the engineering team if possible, and those who are delivering the project on the ground. It's useful at this stage to involve the land referencers, land agents, and planning and consenting specialists. And this allows us to really get under the skin of a transaction. And from this, I'm looking to understand what the client wants to achieve so I can meet their requirements as the project progresses.
I'd like to pick up a little bit more on that idea of knowing what the client wants to achieve, because you and I have worked together a lot over the years on lots of different projects. And something that I can say for sure is there is no one size fits all approach whenever you're dealing with lateral infrastructure. And there's always going to be a bespoke angle as you try and assess really what the client wants to achieve and how you're going to get there. But there are perhaps some common themes, some mechanisms. So from your point of view, Is it the sort of thing where perhaps a client comes to you with exactly how it wants to achieve its end goal? Or is it more often that a client will come to you and say, here's where I'd like to get to, and then you help and you fill in the legals?
I think there's not really one way to do all of these things. You have to look at what the options are, what the project requirements are, and pick the best way for the client and their particular project. If we take, for example, the need to link up an industrial unit to a substation, through different landowner parcels. You could do this via options for easements, followed with easements, or you might be looking to secure a more permanent interest, such as a freehold acquisition or even a lease. And this is where those early discussions can really help us to set the direction for the project. We work closely with the client team so that hopefully we all get to the same page and drive it forward together at the required rate. In other sheds, we tend to work very closely with our planning team from the start of the matter so that we can deliver a project that the client requires from a planning perspective as well.
To see what you mean. So by working really closely hand in glove with the clients, the people who are really driving that deal, they understand the very fabric of it. You can then bring your expertise in, talk about the different options, work together, and then come up with the solution and the way in which you're going to proceed with that project. So we started, got things off on the right foot with that mechanism and that ethos of working together and really getting under the skin of the deal, as you said. We've had those initial conversations about perhaps how we're going to achieve it, where we want to go in terms of how we're going to structure the transaction, the different documentation. What happens next? How does all of that get fed into the legals?
So I think starting off with some really good and strong land referencing is always helpful. This will identify, hopefully, particular infrastructure constraints at the outset, which just allows us to build those requirements into the documents. Hopefully getting early positive engagement with landowners and getting landowners to take legal advice really at an early stage so that they have professional input into the heads of terms can also be useful. And then really feeding into those heads of terms, it's really helpful if we can have clear, consistent heads of terms, which then help us to produce template documents, which can be rolled out and bespoke to specific landowners depending on what the requirements for those landowners are. Another thing I would say that we found useful is agreeing milestones at the start of a matter so that we have a real timetable with landowner solicitors and their agents as to the number of days it might take to turn a document or for replies to inquiries to be returned. And just generally proactively engaging or suggesting an all parties call or meeting at the start can really help to move things in the right direction.
I see. So it's that idea of bringing everyone on board, making sure everyone knows exactly what the expectations are, what the deal is going to be made up of, and once everyone's happy with that, just pushing it forward in a bit of a team effort there.
Yes, and I think that helps you to unlock stalemate, so to speak. If you've got a bit of a tricky landowner, you're not sure why. If you have a meeting, then usually we can reach a solution fairly quickly.
I see. And having got that sort of early buy-in from everyone and being able to show, you know what, this is what we decided and why we think this works for everyone, landowner, developer, whoever it is, that really is going to take everyone with you, isn't it?
Yes, I think so.
Great. So you mentioned in that bit there to do with land referencing and really sort of assessing out who the owners are and perhaps some of the things to do with title and what might come up. Now, I know that in some of these transactions, a client might ask their land agents to undertake a bit of high-level property title due diligence review before bringing in lawyers to do that in a bit more detail. What are the sort of things that the land agents should be really looking out for at such an early stage?
I think key is obviously checking the ownership. You need to know that the person that the developer is securing the rights with is actually the correct owner of the land, the freehold, whether that be a freehold owner or a long leasehold owner. Otherwise, you might have spent a long time agreeing heads of terms and find out that that sort of effort has been slightly wasted. We also try to review restrictive covenants that may prevent or restrict the developer from doing certain works in that area. It might be at that stage that, and hopefully this is an early stage, the developer looks to decide that another route might be better for their cable. And this is also can be the same case with restrictions on title, where there might be things that are just going to be too difficult for a developer to overcome, or just make it a longer process depending on what the project timetable is. It's also really interesting to look at leases and the leasehold interests, because they can sometimes include encumbrances which could delay a project or encumber a project, just not in the way that your client or the developer requires. So just really understanding the viability of a project and its route before a developer has incurred too many costs, it is helpful, and having a clear set of negotiables and non-negotiables at the outset can help to drive your negotiations in the right way.
I see. So what the picture that we're developing here is the idea that by looking at a lot of these things early on, you're able to see if there needs to be more significant changes in order to avoid perhaps spending those costs and hitting a brick wall later, or something that becomes more challenging if perhaps you can deal with it early on. And that's something I'd like to look at next. Because you mentioned really consistent heads of terms and comprehensive, and making sure that the landowners are in agreement and they know exactly what the expectations are. Are there any points that perhaps sometimes don't quite make it into heads of terms? Maybe there's something that is not expected to be controversial, just part of a usual sort of deal. But perhaps if a landowner maybe hasn't done many of these deals or not too aware of it, it could be quite useful to flesh these points out early, just in case they were to cause delay later.
Yes, absolutely. I mean, something as basic, I suppose, as the restriction on title that we would put in place if our client had entered into an option agreement. That obviously just prevents the landowner from disposing of the property to a third party without that third party being bound by our option agreement. So ensuring that the landowner is aware that if they are going to sell their interest, that incoming purchaser will need to enter into a deed of covenant, will obviously make it, a bit smoother if you talk about that up front. And that's where sometimes this initial meeting with landowners or a group of landowners can help, because you can chat through those things with landowners and their agents, get them to understand that that's not necessarily something that has to go into the detail of the heads of terms, but if they know it's coming, it's not going to delay the process later on. Similarly, restrictive covenants. So as a developer, you would probably require protections in place for the integrity of the cable. So, for example, not to build over or not to plant within a specific distance. Again, these are all fairly standard, but may come as a slight shock to some of the landowners. So from our perspective, we sort of know what we're looking for, and having those early conversations can really help. Also, sorry, go on, Joe.
Well, no, I was just about to say, I see how the early conversations then with the landowners, it's a lot easier to have that conversation early on to explain why you need it and what needs to go into the documents, and to help balance it, recognizing that they are the ones who own the land, who perhaps will be working the land generally, and so they'll have their own concerns.
Yes, and I think the other thing that's sometimes useful is quite a high level rights that the project requires, because it's only then really that it comes out that the landowner might not be expecting a particular right of access or a right of access in a particular place, and obviously having that dialogue early on can help. And I suppose the other thing is thinking about assignability. Usually a developer will want the ability to sell on the project in future, and sometimes landowners may not have envisaged that they were going to be dealing with other people. They build up a relationship with a particular developer and expect that the project will be with them for the duration.
Okay, so it's all about that relationship, just being transparent and sort of comprehensive, really, in what your expectations are. Now, from a landowner point of view, they're about the importance of what rights perhaps a developer needs, what restricted covenants there are. They'll want to be working their own land, dealing with their own land in certain ways, but also what could be quite a major point for a landowner, understandably, is the consideration that they will be receiving, and how and when they're going to be receiving it. Are there different ways in a sort of lateral infrastructure context that this might get structured?
Yes, I mean, sometimes we see the use of incentive payments. These can be at heads of term stage, so payment to return your signed heads of terms by a certain date, or it might be on exchange of the option agreement, which actually we can sometimes find works better because, of course, the difficulty with the heads of terms is they're not a legally binding document, and therefore, whilst it does show intention of the parties and parties working towards the same interest, it's actually the exchange of the option agreement that's helpful and more relevant for the developer. The other thing we see developers doing are stages of payments. So you might have a percentage on exchange of option agreement, a further percentage being paid for construction, and then a further percentage being paid for completion. This is particularly important when you've got deeds of easement, because obviously until you've got a registered legal easement, it won't actually be a legal easement. So it's really important that you can get the landowner still on board to sign up and complete that.
I see what you mean. So what we'll have then is throughout those early discussions, presumably the developer comes up with its own plan of how it needs to structure it, perhaps in line with its own financing, its own project milestones, that sort of thing. And
Yes,
then that messaging gets fed in through negotiations at heads of term stage.
usually yes, or they might have a sort of a wide, as some clients might have a wider sort of policy on how they structure payments and that sort of thing.
Okay. So again, it's about being clear with the landowners. So then the landowners' expectations are managed there as well. They know exactly where they stand, what they will be receiving when, and then that all can flow into the documentation and hopefully wouldn't be a problem around negotiation time.
That's the idea, yes.
Something else slightly different that I think it would be really good to hear your views on is the use of tech in this space, because we know that tech is being used across the sector, both in a real estate context, but also in a developer lateral infrastructure context. And there are more and more capabilities that we're able to leverage on these sorts of deals. Could you talk to us a little bit about how you're seeing tech used and how useful that is?
Yes, of course. Well, we're using a number of artificial intelligence and geospatial systems to access, analyse and efficiently report data, which is held at the Land Registry. Digital systems can really visualise and review the data that has historically been held or reviewed on paper. And digital review is obviously a much more efficient way to deal with title review. It saves time, reduces the risk, and allows for swifter reviews, especially of lease information. We have systems that allow us to overlay highways and planning information and even conduct a virtual site visit. And we also use legal practice management methodologies to allow us to deliver projects on time and within budget.
So I suppose the idea there is perhaps if you're working on a smaller deal, then maybe it's easier for everyone to keep oversight through just emails or a usual process. Whereas when you've got a much larger deal with a lot of landowners, huge swathes of land, maybe you leverage some of those legal project management tools in order to make sure that everyone is as up to date as they need to be and has the data that they need. Is that fair?
Yes, I think so. And obviously it depends on client requirements. Some clients won't require a detailed review and others will. So we try to adjust to meet those requirements.
Okay. We talked right at the outset, and something that's been sort of been present throughout this podcast about how setting the tone is really important with these deals as you take all of these people um, on that journey with you. And of course, we've got the tone, we've got the different legal points that come up. From a practical sense, and just as we sort of look towards the end of this podcast and moving that way, are there any I suppose, practical working points that you'd really recommend that people get on board with early on whenever they're working on these sorts of projects?
I mean, I think this applies whether you're working on a large or small scale project, is that one team working and communication protocols. We try to consider ourselves as an extension of the client's in-house legal and project team and work as a team with agents rather than trying to double handle with the potential for things to get lost in translation. Going back to what I said at the start, really understanding that deal, getting under the skin of a transaction and understanding exactly what the client wants and how they're going to deliver the project together with those timescales all help. And one of the things that we've seen work over the years is this three-pronged approach. So our relationship, we have a strong relationship, hopefully, with the landowner solicitors. The client has a good relationship with the landowner, and the agent, hopefully, a good relationship with the landowner's agent. And so we can all progress together. And that's really where, the role of a land agent really comes into fruition, because they essentially can embed that relationship between all those three parties and really help to progress the deal in the right direction. And just having those responsive and proactive relationships should help to deliver a project on time.
I see. So having all those people who really understand all the concerns of all the parties and how those compromises can be made to achieve what everyone needs, from having been involved very closely and built those relationships early on, that just carries on throughout the whole project, and hopefully overcomes any challenges, any concerns, and reaches those compromises in a productive way.
Yeah, and actually that's quite an important point you touched on there, Joe, because it's not just a case of, right, we'll agree the heads of terms and get the legal documentation done. In lots of these cases, the projects go on for sort of 10 years or more, and there's a real need to have a relationship between the landowner and the developer, because once the legal documents are done, they're going to be working on construction, and they're going to be things that come up during that relationship that mean it needs to be strong and important. So if you have that transparency at the start, hopefully that allows for a good working relationship going forward.
Well, I think that's a perfect point to end on. So, Nadine, thank you very much for joining and for giving us the benefits of your experience. And to everyone, thank you very much for listening.